There y'all go.
Thanks. So there we go. Thanks. Thanks everyone for being here tonight. And thank you, ABC, for hosting this really important presentation. I'm really happy to facilitate the conversation about tenant rights and resources because it goes without saying, and why you're here tonight, that receiving education about processes, getting answers to questions, knowing where to turn if you have a concern about your rights or any housing need is really essential to not only an enjoyable housing experience, but a sustainable one. So we really hope that you find the presentation informative, and then together that we spread the information learned about your rights, about what discrimination looks like, but also about where to get more answers to all of your neighborhoods, your communities, because we really want everyone to know, from tenants to small owners to management companies, even to realtors, about, we want folks to be informed, and we want everyone to know about tenant rights in order to really make sure that our city is welcoming and safe. So as Chris said, my name is Maura Pensak. I'm the housing liaison for the city of Cambridge. And I'm joined also, as he said, by Susan Hegel, who's the housing attorney for the Cambridge Somerville Legal Services, which is an office of Greater Boston Legal Services, and by Carolina Almonte, who is the attorney investigator for the Cambridge Human Rights Commission. Before I turn it over to them, I'm just going to say a few words about what the Office of Housing Liaison is and what we do, and then just note one of the important ordinances that came into play in October of 2020, the Tenant Rights and Resources Notification Ordinance. So my office, the Office of Housing Liaison, was actually created in 2019. Doesn't feel like it was 3 years ago because of COVID, but it was. And we're part of the city managers team. Right now, there are 2 of us. We're growing. We're going to add some staff in the coming year, but we are part of the city managers team. And we're here to respond to really a myriad of housing questions and housing related concerns and needs. We assist pretty much anyone who's a resident in Cambridge, whether they're a homeowner, a tenant, or an unhoused resident. And we work across all the departments: Community Development Department, the Department of Human Service Programs, especially with the Multi-Service Center, which is where I'm housed, the Human Rights Commission, who is here tonight, and a lot with the Inspection Services Department team. We also work with our affordable providers and nonprofit partners. And together, what we've tried to do over the past couple of years is really to increase our collaboration between all the services and resources so that we can ensure that there's no wrong door to getting assistance. One of the outcomes of that collaboration has been the House in Cambridge campaign that began a year ago this past April. And while we've been able to do a few in-person events at the library over the past couple of months, because of COVID, we have mostly done webinars, but we've done basically a webinar every month on various topics, from tenant rights to accessing affordable housing to protecting your home from rodents, because that's something that we all have to work on, whether it's tenants or owners. And all of those webinars are on the Housing Liaison webpage on the city website. And many have been translated into multiple languages. We're working on translating them all. The next session will be this coming Tuesday at 3 o'clock. And the topic is unlocking your electric bill. As you all know, the utilities have skyrocketed. So I hope you can tune into that. But if not, it will be recorded and available. So back to the Tenant Rights and Resource Notification Ordinance that I want to mention. It was passed in September of 2020 and became effective on October 14th, 2020. And the reason why I really want to note it is that because it was implemented during COVID, a lot of folks think it was just part of the COVID response and then it no longer is in play right now. But it hasn't ended. It's a standing ordinance. It's available again online on the Housing Liaison website. And the ordinance requires that owners, no matter how large or small, provide every tenant a city-created tenant rights and resource guide at the inception of a tenancy and or at any stage of non-renewal. So if you get a notice to quit, or if the owner just decides you're not going to renew your lease or your tenant agreement, they are supposed to give you this 5-page guide that we created that outlines a little bit of what you're going to hear tonight and gives important information about how to contact us and myriad resources throughout the city. If you haven't received it from your owner, please ask them about it. Reach out to me, direct the owner to me. I can say that most large management companies are aware of this and do participate in the program. But you know, it's hard to get information to every small owner. So please let me know, because we really want to make sure everybody's on board. So with that, I am going to turn it over to Susan. And just so you know, after she presents, I will be moderating the questions that come into the chat for her. And then we will go to Carolina and do the same. And then there'll be questions for everyone that will answer any other questions that are still out there at the end. So Susan, you know, is the housing attorney at Cambridge Somerville Legal Services. And I personally think that she's the guru of tenant rights and information and of all legal processes regarding tenants in the scope of housing. So she's going to talk some about the basic eviction process, and also she has developed some proactively frequently asked questions that she's going to present and answer for you. But again, don't be afraid to put a question in the chat, and when she's finished, we will get to them. Thanks.
Okay, good evening, everybody. Again, my name is Susan Hegel, and I work at Cambridge and Somerville Legal Services. Briefly, for those that don't know about legal services, we are a small neighborhood office of Greater Boston Legal Services. We're a private nonprofit. Our office is relatively small, under 10 people, and we primarily serve people in Cambridge, Somerville, and 4 other towns on housing matters and public benefits. So if people are denied or terminated from food stamps or EAEDC or Mass Health, if you're being evicted, if you're being denied housing, and you live in our service area, and we do have income guidelines, you can contact our office and we would evaluate your case. So what I wanted to first do is talk a little bit about rents and rent increases, and then a little bit more about the eviction process. That's not the first slide. That's the first slide. Thank you. So not everybody knows, but basically, if you're living in private market housing, there is, for the most part, no limit on what the owner can charge for rent. You know, absent obviously rent control. So if you have a lease that does fix the rent for the period of the lease, there are some deed restrictions, or if an owner is going to be converting your apartment to condominiums and selling the unit to an owner, those are really the only 3 exceptions to any kind of limit on rent increases. So again, basically an owner can charge whatever they want. I did want to sort of point out that the tenant, either alone or as part of a tenant group, could try to negotiate for a smaller rent increase. And where buildings have been faced, either with threatened or actual rent increases, usually when buildings are sold, tenants have reached out to Maura or the multi-service center, and we have done sort of joint presentations on tenants' rights and what you could do, to try to act together as a group to lessen the impact of rent increases. For those that have any kind of government involved housing, that would be public housing or Section 8 or multifamily subsidized housing, inclusionary zoning, tax credits, and some rehab loans that are through the city, funneled through nonprofits, those do place a limit on what rent can be charged by the owner. Next slide. So for tenant-based Section 8 or housing choice vouchers, these are probably one of the most common types of housing in Cambridge. The only limit really is that the rent has to be reasonable, which in this rental market is not much of a limit. So tenants are often paying much higher than the normal 30% of their income, but that there is that rent reasonableness limit to Section 8 tenants. For multifamily and public housing and other types of government involved, the rent limit is going to depend on the program, but generally tenants pay 30% of their income. And there are some exceptions to that, but absent a lease or rent control or some government involvement, there really is no limit on what landlords can charge or tenants have to pay for rent. So next slide. So as people know, there had been an eviction moratorium during COVID. It was lifted in October of 2020. And now evictions can proceed. Next slide. So generally the very first step in an eviction is the owner will send you a notice to quit. There's no special form for that. It can be left by a constable or sheriff. It could be mailed to you. So no special way of delivery, no special form, but it does have to basically terminate your tenancy by a certain date. But it's important to remember that that date does not mean you have to move. Okay, only a court can evict you, involuntarily. So just getting a notice to quit, many people get it and immediately panic and move. So I would just urge people, if you get a notice, don't move. Contact the multi-service center or, Maura or others at the multi-service center, and they can get you connected with, services to try to prevent the eviction. So generally in Massachusetts, there's 3 kinds of evictions, and people's rights and the procedure are going to depend on the type of eviction in part. So the first is no fault eviction. So it means the tenant didn't do anything wrong, that again, without having a lease or any kind of government involvement, a landlord could evict for any or no reason. So they would just simply say, I'm terminating your tenancy. And if they follow the proper procedure in the law, they don't need to say, anything about whether you're a bad tenant or they have a business reason. The second type of an eviction is tenant fault. So it's where the landlord claims that the tenant did something wrong. So your tenant's rights and the procedure are going to be a little bit more limited in those types of evictions. And then the third is non-payment of rent. So if a tenant hasn't paid the rent, they would get a notice, and again, their rights in the court procedure are going to vary from the other 2 types of evictions. In Cambridge, for Cambridge residents, evictions can be filed in either the Cambridge District Court, which is located in Medford on Route 16, or they can be filed in the Eastern Housing Court, which is located in Boston. Before COVID, the Eastern Housing Court had a Middlesex County session located first at Cambridge and then at Somerville District Court. And they are resuming now, I think as of last month, holding Cambridge and Somerville and a few other town evictions back in the Somerville District Court. The landlord chooses where to file a case, so they could file it in either court. But if they do file it in district court, the tenant has a right to transfer it into housing court. And there's pros and cons to that. Next slide. So landlords often think you get the notice to quit and you have to leave, and that's the end of the story. But if you look at the next slide, you'll see that there's many steps in between. So what I was going to do is explain a little bit about each of the steps and your rights and why it's really important to try to get legal help as soon as possible. But then if you can't get legal help, at the end, I have some resources where you could try to represent yourself. So again, the very first step is generally a notice to quit, or your lease has expired. And the notice to quit can be a 7-day notice if it's a violation of a lease. It can be a 14-day notice for non-payment of rent. It could be a 30-day or rental period notice. And if a landlord is not giving a reason or a business reason, or in certain kinds of subsidized housing. And there are even circumstances where an owner has to give a 90-day notice. So again, the rights are going to depend on the type of tenancy and the type of eviction, the reason for the eviction, but you are generally entitled to a written notice to move. The next step is after that notice period is over. So after the 7, the 14, or 30 days is over, a constable or a sheriff will give you what's called a summary process summons and complaint. And unlike other court cases, the tenant gets this piece of paper first before it's filed with the court. So when you get that piece of paper, if you have not already sought legal help, you definitely need to try to get legal help at that point. On the bottom of the court complaint, it will have something that's called an entry date, and that's the date it's going to get filed with the court. And then once it gets filed with the court, that can be anywhere between 7 and 30 days after the tenant has gotten the complaint. The next step is, this is just during COVID and probably for at least the next year, the court is going to mail the landlord and the tenant a notice of a court date. And that court date right now is still being held by Zoom. And it's for the purpose is for mediation. So if the case is in housing court, they're running about 3 to 4 weeks between filing it and getting your hearing. In district court, they're very quick. You get about a week's notice. So it's really important to show up at the mediation. In housing court, they have mediators on staff that will try to reach an agreement between the parties. In district court, they will often send you to mediators that are under contract with the district court, and you'll have a mediation at a later date. It's really important not to ignore the court notices. Some of them are very tiny print and very dense, but there will be a court date on there, and sort of buried in the notice, it will tell you that you have 3 business days before that mediation to file your answer. So that's why it's really important to get a hold of a lawyer right away. Your answer would be, why you should not be evicted. So if you're being evicted for not paying your rent, maybe, if you're in public or subsidized housing, the rent is not calculated properly, or maybe you did pay it, or maybe the landlord is seeking to evict you for things that are not rent, but that are late fees or damage or something else. Or so you could have various defenses to the eviction. You could also, in non-payment and no fault cases, countersue the landlord for anything the landlord did wrong. So if they violated the security deposit, if there's bad conditions. But you can only raise those things if you put it in the answer that's then filed with the court and given to the landlord 3 days before the mediation, 3 business days. So you have to be careful of holidays and weekends. So sometimes at mediation, the landlord will just drop the case, or you'll come to an agreement to, postpone things. If rent is paid timely, then the case goes away. But if mediation does not result in any kind of settlement agreement, the next step would be to have a trial. And at the trial, either the court's going to find in the tenant's favor and dismiss the case, or the court will find in the landlord's favor. Right now, it's for trials before a judge. It's probably at least 2 weeks, and probably longer for jury trials. In housing court, and district court, they have not been happening. And I know for the last district court, like in Somerville, they're not scheduling anything until 2023, because it's all the criminal cases and other cases take precedence over summary process. So it is quite a ways, a long period to wait for trial. So I just wanted to urge people again, when you at every step of the way, try to get legal help, that once you pass your answer date, it's often very hard to help people, but it's not hopeless. So you should get in touch with somebody as soon as possible. And again, if a case is filed in district court, you can transfer it to housing court up until the day before your trial. And then the whole process will start over with a new mediation. So next slide. So for people that are living in subsidized housing, so this would be public housing or Section 8s that belong to the apartment or things like that. Because you have a subsidy, you have a lot more at stake, and the government either offers or requires some steps before a landlord could go into court. So in public housing, you have a right to an informal or private conference, and sometimes a grievance hearing. In other kinds of housing, like the Section 8 project-based housing, you do have a right to an informal conference, but only if you request it during your notice period. So again, it's really important when you get any eviction papers to read them very, very carefully and make sure you exercise your rights by the certain deadlines, and always put stuff in writing. In public and multifamily housing, Section 8 private base, generally you cannot be evicted unless you violate the lease or the program rules. They need to have some good cause to evict you. For tenants with tenant-based vouchers, a number of years ago, they sort of changed it so that you can be evicted for tenant fault, but also for the either no fault at the end of a lease or an owner's business or personal reason. So if an owner wants more rent than the housing authority or you approve, you can end up getting evicted from a voucher housing. If the property is being sold and they want it empty, you could be evicted from voucher housing. You can't be evicted for those reasons for public housing or multifamily, but you can for tenant-based voucher housing. But hopefully, if you are being evicted for a reason that's not your fault, you can take your voucher and relocate to another apartment. It's just been, I guess as you'll hear later, really hard to find an apartment, and there's a lot of subtle discrimination against voucher holders. And then the last slide. So if people don't have a lawyer, these are some the first thing would be to contact the multi-service because they can get you connected to services. But if you, for some reason, can't or it's too late, there's something called the Mass Legal Resource Finder. And that's good for all types of legal problems, no matter where you live in Massachusetts. You have the little web link there and you can go into that and they ask you a few basic questions about, your legal issue. Is it housing? Is it benefits? Where you live? And if you're under or over 60, because different programs cover different age groups. And it will tell you the legal services that covers that legal problem for that age group. If you are over 60, there is no strict income limit for legal services. If you do have a court complaint and you don't have any legal help, there's a website called masslegalhelp.org, and that explains the eviction process, and it has a lot of packets to help people file an answer. You can also go to gbls.org MAID, and that's another sort of automated way to explain your answer and your documents for eviction. The advantage of MAID is that you can do it on your phone and you can email it right to the court. And then the Court Service Center, which is located at the Brook Courthouse, they are now doing in-person on Tuesdays and Thursdays and remote the rest of the week. And they are staff attorneys there that will help people fill out forms and navigate the court process. They don't give any advice, but they can help you do enough to protect your rights. And last thing, I will go through the questions in a minute. I forgot to mention when I was talking a little bit about the rents is that, and I can send the link to Chris and he could send it out. But I think last week, I don't know if anyone watched it, John Oliver had a whole show on raising rents and evictions. And he really did a really good job about summarizing the problem and raising attention to it. So I would definitely watch it. You can watch it on YouTube. Okay, so questions in the chat?
Yeah, so I can, the first one, it's to you, Susan, but I just also want to clarify a few things. It's what aspect of this process is most surprising to the tenants who come to the multi-service center to work with you? Which thing do most people often not realize of the folks? So one thing I just wanted to clarify. So Susan is from Cambridge Somerville Legal Services. I am the Office Housing Liaison, housed in the multi-service center, but part of the city manager's team. We all work very closely together. But it's 3 different offices, and people will access, again, this is part of the no wrong door. People will access any one of us to get their questions answered. And in terms of this question, I would say that many people, I think, as Susan pointed out, and Susan can respond to this also, are they get the notice to quit and they think they have to leave. And that is the biggest concern, and the thing that we all, no matter which door they enter, we all respond to in the same way, that there's a process. You do not have to leave. Only a court can make you leave. And then we try to talk people through the process. And then again, depending on the situation, we'll connect them with Cambridge Somerville Legal Services or De Novo or another Harvard Legal Aid, depending on the situation, or sometimes we can mediate the situation. So that is I don't know, Susan, if you have anything to add to that in terms of basically the greatest.
No, you did a good summary.
The other is times when a low-income tenant in naturally affordable housing might be reluctant to ask for repairs or pest control for fear the landlord will raise the rent in retaliation. Is there any advice on navigating this? And that's to all of us. Susan, I know you can talk a lot about retaliation. I'm going to turn that over to you, and then I just want to mention how my office works very closely with the Inspection Services Department.
So if people have, bad conditions, I always think it's a good idea to, first reach out to the landlord in writing, politely, so that there's a written record about the conditions, and asking the landlord to notify you about when they can come in to address it. If that's not getting you anywhere, reaching out to multi-service and Maura's, to try to get compliance from the landlord. If that doesn't work, calling the city for an inspection. You could always call the city for an inspection right away. You don't have to go through the earlier steps. I just think it's, generally more advisable if you want to sort of keep the peace with the landlord and give him a chance to try to work things out first, and then call the city. They will come out and inspect and issue a report and give the landlord time to make the repairs. You can keep pressure on the city. Often they, at least pre-COVID, they would give the landlord a certain period of time to remedy it, and then they would keep extending and extending and extending it, and they would rarely go into court. But they can go into court and bring criminal action against the landlord, and that usually gets compliance. If it's an issue that's affecting the whole building or a large group of tenants, tenants can join together and file what's called a tenant petition and get, once you have your Board of Health report or inspectional services and nothing is getting done, you can file a tenant petition and get the court to order the landlord to make repairs. As Maura mentioned, there is, a statute for retaliation. I have been practicing for like 30 something years, and I've won on retaliation twice. It's really hard to prove. So basically, if a tenant notifies the landlord in writing, not verbally, about bad conditions, or contacts inspectional services about bad conditions, and the landlord then within 6 months changes the terms of the tenancy or tries to evict, that raises what's called a presumption of retaliation. But the landlord would then have to show that they would have done the same thing at the same time, even if you had not called inspectional services or sent the notice. So landlords, if you're behind in your rent, they'll say, no, I wasn't evicting because you called inspectional services. I was evicting because you were behind in your rent. So it is sort of a difficult thing to win, at least from my perspective, but it is an important right. So.
Yeah, and I would just say, again, reaching out to folks, sometimes, even, and it's part of what my office can do, is just kind of carry the city name to the landlord and kind of work through things. And I appreciate in this question that the participant mentioned, naturally affordable being, meaning it's unsubsidized but old and generally below market. And we see a lot of that, that if it's, and I see both. I see, small owners who just don't have a lot of finances to fix things or the wherewithal, and I see absentee landlords. And, depending on the situation, we'll, again, working with ISD, kind of bringing the city's authority, if you will, to kind of do some mediation. Sometimes we can make things make things whole and not, have it be where the rent is raised or where we have to worry about retaliation. I think also we get a lot of questions about retaliation, and I don't know what Susan has seen. I don't see that many. I get a lot of calls from people saying, this is going on, that's going on. We connect with ISD, and usually we can work things out. So I'm not saying it doesn't happen. If it does, or even let's try to prevent it. But if it does, we can also work with you. Just maybe we'll take another question. I guess there is not. I was going to take one other question before we move. Oh, sorry. Someone did ask about de novo and that they attend housing court. De novo does still exist. And I think this question refers to the lawyer for the day. Susan, I don't know if you can.
Yes. So there is still the lawyer for the day. When de novo will be in the Somerville District Court, which covers Cambridge, when the housing court will be sitting there. So they will be providing, advice at the courthouse there. There's a rotation between Greater Boston Legal Services, de novo, Harvard Legal Aid, Volunteer Lawyers Project, and some other programs to cover lawyer for the day in the Boston Housing Court. The problem is that in the past, they would hold hearings, every Thursday or every Wednesday. Now they're holding them every day of the week, and they're doing 9, 11, 1, all different times, and some is remote and some is in person. So it's been very challenging to continue with the lawyer for the day. And I guess, to be honest, it's sort of hit or miss. But it's worth, going down to the courthouse and ask, or calling the clerk's office and asking for the lawyer for the day.
Great. And there was one other question. What if inspectional services aren't responsive after landlord has failed to act? Please call me. I can help get connected directly to the manager at inspectional services. Again, I work really closely with them. They do try to follow up with every concern, every complaint, but like any of us, things might fall through the cracks. So, let me know. We're on speed dial with each other, and we'll get that taken care of, because they do very much want to follow up. Okay, I'm gonna, I keep saying one more question. If a voucher tenant pays their portion of rent, but CHA does not, or is always late, can a tenant be evicted? No, in fact, they shouldn't be charged for a fee, but I'm going to turn that over to Susan. There is one person with their hand raised, so I don't know, Chris, if you want to, after Susan responds to this, let that person ask the question, and then we should move to Carolina. And then we can continue to take questions that are for Susan or for any of us after Carolina presents.
So Maura's right that legally tenant cannot be evicted for the housing authority's failure to make its payment. But landlords will often try, so it's really important to get legal help. And I didn't want to be so discouraging about retaliation and getting repairs. So, if things are really bad in your apartment, you should reach out to the landlord and inspectional services. And, you do have the landlord can't raise the rent. The landlord can certainly try to raise the rent, but you do have defenses to it and can push back. So I just don't want to encourage people or be very overly pessimistic. And I guess there's somebody.
Sorry.
No, there's somebody with a hand raised.
Yeah, and I think so. Gabriel had their hand raised, but did put the question in the chat. Gabriel, I think this is a very specific situation to to you, so I'm going to suggest that you give myself or Susan a call, tomorrow or something, and you can respond to your individual situation. Okay, so we will turn it over to Carolina. So as Susan is the guru of tenant rights and courts, Carolina is the guru and the expert on discrimination of all kinds, including and especially housing. And she has worked for the Attorney General and is now, we're very happy to have her as the attorney investigator here in Cambridge. So we will turn it over to Carolina.
Thanks, Maura, so much. I appreciate it. So I'm Carolina Almonte. I'm so happy to be here. My PowerPoint presentation is a bit longer, but I'm always happy to answer questions at any point during this presentation or after, if you want to give me a call anytime. So before I get started, just a quick thing. The commission does not and cannot provide legal advice. So nothing in today's presentation should be considered legal advice. If you do need to consult an attorney with a specific legal question, we could provide referrals or legal services contacts. So just wanted to let you know about that. Next slide, please. So this is just a quick overview of what we do at the Human Rights Commission. We're a city law enforcement agency. We're located at 51 Inman Street on the second floor. We're not in City Hall, we're down the street. And our job is to receive and investigate complaints of discrimination that occur in the city of Cambridge. So we do primarily work in the housing space, but we also investigate employment discrimination complaints and public accommodations, and sometimes education-related discrimination complaints. Our role is to enforce our two city ordinances. So we don't necessarily enforce the state anti-discrimination statute, which is 151B, even though our ordinance is very similar. So the Human Rights Ordinance covers employment and public accommodations, and we have a fair housing ordinance that we enforce. And our main goal is to look at discrimination claims based on protected categories, which I'll discuss in more detail later on. Next slide. So now that you have a general understanding of the Human Rights Commission, one really important thing to discuss is jurisdiction, which is basically just the authority granted by our ordinance to investigate and rule on legal matters. So that's based on the subject matter of the case and the geographical region in which the issue took place. So one important thing to keep in mind is that we can accept cases if the discrimination occurred, like I said, in the city of Cambridge. This means that a complainant or a person who is filing a complaint with us, they can live outside of the city. You could live in Somerville, but apply for housing in Cambridge, and that's fine. So the respondent business, the salon, the restaurant, if it's a public accommodations complaint, it has to be in the city of Cambridge for us to accept it. And also the alleged discrimination must have occurred within the past 180 days. So that's roughly 6 months. There is an exception to that if it first began longer than 180 days, but it's ongoing. We could look at that. And lastly, the discrimination has to be based on a protected class. So, if you have a housing issue going on, it could very well be a legal issue, but not be a discrimination issue if, the harassment you're experiencing isn't based on a protected class, but maybe because you don't get along with your landlord or there's other facts there. The other quick thing to note is we cannot accept complaints against other City of Cambridge agencies with the, so the Cambridge Housing Authority, we can't accept complaints again, but if there's a complaint against a multi-service center or something else, we don't have authority to investigate those complaints, but the Mass Commission Against Discrimination does, so they could be filed there. So I'll quickly go through our complaint process overview. If you ever want to contact me to file a complaint, I will explain this more slowly and in more detail. But as I mentioned, our role is to investigate complaints of discrimination. We're a neutral investigative agency. So that means that we don't represent either party. So I don't represent a complainant or a respondent or respondents. So that's a person the complaint is filed against. There is absolutely no cost to file a complaint with us. Also, I'll note you can be represented, you just don't have to be. We've had complainants that have even been represented by a legal services attorney or another housing advocate. That's fine, and that would be at your own cost. So generally, our process begins with an interview or an intake with me over the phone, in person, or we have an online intake form. If you're not represented, I would draft your complaint. You would review it, make sure it looks good. Then that complaint is served on the respondent. So that means I mail it out by certified mail. They receive it. Fair housing complaints have to be responded to in about 10 days. So that you would get a copy of the landlord's response or the property manager's response or whoever the complaint is against. And at that point, what I would do is often interview witnesses, review documents, research case law, look at different policies. So complaints could go down two paths. So if I keep going down that path, my goal is to get to the determination stage. So that means I would write something called a determination where I say there's either probable cause that discrimination occurred or lack of probable cause. And I would explain that in that document. But a lot of our cases are actually mediated. Oftentimes people are looking for some sort of a resolution. That could be a monetary payment. It could be, having the landlord attend anti-discrimination training. It could be working with a landlord to approve your reasonable accommodation request, maybe to move to another unit in your building. If you're having issues with another tenant who you believe is harassing you, maybe it's an accommodation to break your lease early because you want to move to a more accessible apartment. We all kind of work together to figure out what that looks like. But a lot of our complaints are resolved in that way. The other thing I'll note is that we are substantially equivalent to the Federal Fair Housing Agency, HUD. They give us authority to investigate federally protected complaints. So not all protected classes are federally protected, but the ones that are, they basically give us the authority to investigate those on their behalf. Last thing I'll say is our process is not adversarial. Oftentimes people, who are afraid of retaliation may say, I'm not sure if I want to file a complaint. I don't want to lose my housing. I'll talk more about retaliation later on, but my approach is really just to try to look into things as neutrally as I can, as thoroughly as I can, and just kind of see if there's an issue and how to correct it. So we want to help the specific complainant and also look to see if there's a wider issue. So now I'll talk about the protected categories or classes, which are basically identity traits. So you'll notice that there are similarities between what the state recognizes and what the city of Cambridge recognizes. Another just quick thing to note is that both majority and minority traits are protected. So for example, men are protected from sex discrimination as well as women. You can be discriminated if you're a member of a group, perceived to be a member of a group, or associated with one of those groups. Oftentimes during these presentations, people find examples helpful. So, regarding active military personnel or veterans, that's protected. An example would be being denied a housing opportunity or charging a higher security deposit if you're a veteran. Age means 18 years or older. So if you're old enough to enter into a contract, you're old enough to sign a lease. Disability, keep in mind that could be physical or mental. So that means folks are protected if they have an impairment, a record of an impairment, perceived to be impaired, or by association. Gender identity is folks who are transgender or in any way gender nonconforming. Sexual orientation, gay, straight, bisexual, pansexual, etc. Marital status and family. So federally it's familial status. Our ordinance calls it family status. So that could be living with someone, married or not. It also applies to family size. This often comes up with lead paint discrimination complaints. So that's when, you notify your landlord that you're pregnant and you're going to have a baby, and they serve you with a notice to quit and saying that you have to leave because they don't want to de-lead. Homes are very dangerous for children under 6 years old if there's lead paint. So we do get some of those kind of complaints. Ancestry and national origin are similar. The difference is national origin is where you are from, and ancestry is your family background. Both are protected. Public assistance and source of income. I'll add that disability and source of income are the two highest complaints that we get in terms of protected classes at our commission. So source of income, means that you can't be discriminated against based on your receipt of any form of public assistance. So that could be Section 8, Social Security, disability, any other rental assistance programs. Race and color. So color is very literal. That's how much melanin we have in our skin, and oftentimes how other people identify us. And race is how we identify. Religion is religious beliefs, even ones that are uncommon. Keep in mind that it could also be atheism. Sex, you can't discriminate based on sex or gender. This includes sexual harassment in the housing environment. And lastly, retaliation. So that's when someone experiences an adverse action for engaging in a protected activity. So who is protected? Our ordinance protects applicants for housing. So that could be public housing, private rental apartments, shelters, commercial spaces. It also protects tenants and apartments. Tenants, okay, so applicants and tenants, sorry, I misread my slide here. So people who are currently living in Cambridge and apartments are protected as well. So it's as you're trying to get housing and also while you're in housing. Also buyers, so people, this market is insane, anyone trying to buy a house as well, that's protected. And complainants or others who speak out against discriminatory practices, as well as credit seekers and credit and mortgage seekers. So the housing providers that are covered under our ordinance are owners, landlords, and their employees. Real estate agents are big, apartment managers, management companies, different banks, mortgage companies, and appraisers, and homeowners insurance companies and public housing authorities. Like I said, we would accept complaints against the Cambridge Housing Authority. And generally, if you're on a deed, you could be liable. So that includes absentee landlords. If you own a property, but you live in Texas, you would still be liable if there's a claim brought against you. One exception that we sometimes see during an intake, I'll often ask a complainant, do you know the makeup of the property? Because there is an exception regarding our ordinance when it comes to two-family owner-occupied homes, which means that our ordinance generally does not apply. Federally, it's a few more units. I think it's 4, but basically it's called the Miss Murphy exception because that's supposed to be a hypothetical elderly widow who has converted a portion of her home into a rental apartment to supplement her limited income. As there always is, there's exceptions to exceptions. So this does not apply to rental advertising. So that means that Ms. Murphy cannot run a discriminatory advertisement indicating, for example, that a certain religious group is not welcome to rent her apartment. And also this exception does not apply when a real estate agent is representing the property owner. And then the last thing to know is that HUD takes the position that the Civil Rights Act of 1866 makes it illegal to discriminate based on race. So as such, there's no exception from the law when dealing with race. So next, I'm going to go quickly through different forms of housing discrimination. You can move to the next slide. So these are kind of the buckets that the majority of our complaints fall in. So disparate treatment, otherwise known as discriminatory intent. So that just means treating someone differently because of their membership in a protected class. So when we look at disparate treatment claims at the commission, we look for similarly situated comparators. For example, a landlord charging a person of one race higher rent than a person of another race. Disparate impact is sometimes known as discriminatory effects. So that's when there's some sort of policy or procedure that is facially neutral, but then it ends up having a discriminatory effect. So one example would be requiring all applicants to have full-time employment, for example, which, as you can suspect, would have a discriminatory effect on people with disabilities and veterans. And another example could be a seemingly neutral policy of not leasing to applicants with a prior criminal conviction. So that could lead to disparate impact liability because of how that policy could adversely affect members of a specific protected class. Next is harassment, which you may be familiar with, such as any conduct that is unwanted or offensive and related to a protected class. It could also be sexual or non-sexual. I'll talk about that later on. In accommodation, those are related to our disability-related complaints. So that's when you ask for a change or an adjustment made on behalf of a tenant, regarding the ways things usually are done. That would allow that individual with a disability to be awarded the same opportunities to reside in their given home comfortably. And then lastly, retaliation. So fair housing laws define retaliation as unlawful coercion, intimidation, threats, or interference with anyone who exercises or enjoys fair housing rights. I think, as Susan stated, these kind of claims can be difficult to prove, but definitely ones that we often get, especially when people are alleging that after filing a complaint with us, even after a complaint is resolved, they experience a negative kind of targeted treatment. They're more than welcome to file an additional complaint, and we look at it just as thoroughly to see if there is retaliation there. So as I mentioned, one of the most common discrimination claims that we see here are allegations of disability discrimination. So I'll quickly go through the definition of disability again. That could be a physical or mental impairment which substantially limits one or more major life activities. So based on this definition, a broken arm that heals normally would not be considered a disability. Also, a person needs to have a record of having such an impairment, or they're perceived as having an impairment. And a perceived disability does not give rise to an accommodation requirement, but can be the basis for a discrimination claim. Just keep that difference in mind. And then also remember, even though there's a picture of someone in a wheelchair in the slide, a disability does not need to be visible. So what is a major life activity? These are some examples. This is, there's more than what's in this list, but that could be caring for oneself, walking, seeing, speaking, learning, working, sitting, etc. So those are what would be defined as a major life activity. There are a few exclusions that may apply regarding who counts as an individual with a disability. So one example are individuals with substance use disorders who are actively using substances. Keep in mind that recovering addicts could potentially be considered people with disabilities, but not if you're actively using. Another example would be personality traits such as irritability, unless it's disability related. And lastly, an uncomplicated pregnancy. So just those are some examples of what may not fall under our jurisdiction. So what can you ask for as a tenant with a disability? There's two things, either an accommodation or a modification. So an accommodation is when you ask your landlord to change a policy or practice that is necessary for you to utilize and enjoy your dwelling to the same extent as a person with a disability. So you may be familiar with an exception to no pets policy to allow your service animal or emotional support animal to live with you, or providing a reserved parking space. One thing I just want to add here is that, the goal of an accommodation is to give you, bring you to kind of the same level as a person without a disability. It's not an added benefit. So just to keep that in mind. And then a modification is when you ask for a structural change to an existing premises that is necessary for you to enjoy your dwelling. So some examples of that would be building a wheelchair ramp, lowering cabinets, adding grab bars in the shower, making it so that you could better enter, a common area in your building, So those are the kind of things that you can ask for. Obviously, this is just some examples. There's a lot of different things that aren't in this list. One thing in terms of analyzing a discrimination complaint regarding disability that we always look at is, did your landlord or property manager have an interactive process with you? So what that means is once a housing provider is on notice of a need for an accommodation, they should initiate this kind of informal interactive process, which means that they, work with the tenant to figure out what is needed so that they can better enjoy their dwelling. So, the process should identify potential reasonable accommodations. Often tenants know what they're looking for. Also, a request for a doctor's note is appropriate. One thing to keep in mind is it does not need to be a physician. It could be any medical provider, including a therapist or a social worker. And ultimately, it has to work. Not all bells and whistles are required. And there's also no requirement that an accommodation request is in writing. Sometimes that could be more helpful, but that's not required for it to be granted. So often the other thing we would look at is if a landlord did deny a reasonable accommodation request, did they have a valid undue or a valid defense? So one example of a valid defense would be an undue hardship. So housing providers do not need to provide all reasonable accommodation requests. For example, if a tenant requests unlimited guest parking for friends and family because that mitigates their social isolation, that would be an example of an added benefit, and it wouldn't necessarily be related to their disability. The way undue hardship is defined is an action requiring significant difficulty or expense when considered in light of a number of factors. So that could be the nature and the cost of the accommodation in relation to the size, the resources, nature and structure of the housing provider's operation. It is determined on a case-by-case basis. I'll give you an example of one that I saw many years ago, but it was a 3-decker that was not owner occupied, and a tenant wanted an elevator put into the building as a reasonable accommodation, which most of the buildings around here are built in 1904, and that would mean basically rebuilding the whole property. So that, of course, was an undue hardship. However, what the landlord did do is put the tenant on a waiting list to be able to move from the 3rd floor to the 1st floor, and that way that would solve that issue. So like I said, we look at these on a case-by-case basis, and we try to, a lot of our disability-related complaints are mediated, where we would look to see if there's a way that we can better help the complainant. So now we're going to jump to another very common discrimination claim we see, which is discriminatory harassment. So basically, when someone makes a discriminatory harassment claim at the commission, we would look for 3 things. The first is, was the harassment unwelcome? The second is, was it severe or pervasive? So harassment does not need to be both severe or pervasive to satisfy this requirement. So that means that one discriminatory action can satisfy this requirement if it is severe enough. And then the alternative, if some unwelcome comments happen over the course of many months, that would also satisfy that. And finally, the harassment needs to be related to a protected class. So the reason why you're being harassed is because your national origin or your race or your disability or sexual orientation. So there's 2 types of discriminatory harassment. The first is a hostile environment. So that's created if verbal or physical conduct is so severe or pervasive that it interferes with a tenant's use or enjoyment of his or her or their home by creating an intimidating, hostile, or offensive environment based on their membership in a protected class. So, some examples could be a staff person in your building telling a, negative joke about an Asian person in front of the manager who does nothing about it. It could be a landlord warning you that you'll be evicted if you continue to have visitors who are Black or, from a different country. Things like that would be harassing conduct. Another form of discriminatory harassment is sexual harassment, which is also broken down into two different buckets. So the first is quid pro quo. So that's harassment that when a housing provider requires a person to submit to unwelcome requests to engage in sexual conduct as a condition to maintaining housing. So that's if a landlord tells you, they won't rent to you unless you have sex with them, or a property manager evicts a tenant after she refuses to perform sexual acts. And the other type of sexual harassment, discriminatory harassment, is when a hostile environment is created. So that's when a housing provider subjects a person to severe or pervasive unwelcome sexual conduct that interferes with the sale, rental, availability, or terms and conditions of their housing. So that could be, a maintenance worker makes inappropriate sexual comments to a tenant, a property manager makes severe, pervasive comments about a tenant's body, a maintenance man sends a tenant pervasive, unwelcome, sexually subjective text to a tenant. Those are just some examples that we would investigate and look at. So now to talk a little bit more about retaliation, it is covered by ordinance. One thing I often tell complainants is to keep in mind that you could file both a discrimination complaint with us and retaliation. It's considered a separate claim and separate action. And the way it's defined by our ordinance is, it states that it is illegal to retaliate against a person for making a complaint, testifying, assisting, or participating in any manner in a proceeding under a complaint process at any time, even after the investigation has been completed. It's also illegal to retaliate against any person because that person reported a discriminatory practice to a housing provider. So if you believe that you have experienced retaliation, you can file a complaint with us, even if you didn't originally have one filed with us. So if you filed with another agency, you could call us and we could talk about it. Those are things that we take very seriously. Some examples of retaliation complaints could be a tenant complaining to a manager that she received a 10-day notice because of her race. The manager gets angry and gives her an eviction notice. Or after a resident was a witness in a complaint investigation, we often do talk to other tenants in the building. The manager tells her that he is keeping an eye on her. So this is just some additional forms of discrimination that we would look at. Inquiring about membership in a protected class, refusing to rent, lease, negotiate, or sell, discriminatory terms and conditions, misrepresenting the availability of housing, saying it's not available for you because you have a voucher, but then you notice it's still being advertised on Zillow or Redfin. Steering, that means telling you that, maybe you should check out some houses in this part of Cambridge rather than this part. Discriminatory advertising, so that's when, no Section 8 allowed, no students allowed, no families, and then use of intimidation or coercion. So this is our contact information. As I mentioned, to file intake with us, we do have an online intake form that I can add to the chat. You could call the number you see there and we can talk over the phone. We also have translation services of any language if that's needed. Also, you can email that email address that I get, and so does our other staff member here. Or you could come meet with me in person. That wasn't an option during the last 2 years really, but now we do have intakes whenever we're open. I'm happy to meet with folks.
Thank you, Carolina. We'll go to questions. I'm going to go to the questions that are directly to you, and then we'll go back to one or others that might be from about the previous presentation. How many complaints do you get in a year? And of those, how many do you find to be probable cause? Any trends going up or down?
Sure. So I would say we get anywhere from 15 to 25 complaints per year. We get more inquiries in that, but sometimes, you know, the discrimination happened too long ago, or it happened outside of the city. So that's when we would refer it out. We don't get many probable cause findings. A lot of that, as I mentioned, it's because a lot of our complaints are mediated. So we work to, you know, it's called a predetermination settlement agreement that I would draft. So it wouldn't get to that point. It would basically be resolved before getting to that stage. So there's really not many probable, maybe 10% of our complaints might be. You know, one thing I'll add is our complaints are very much related to what's going on in real time. So, you know, during the pandemic, I noticed we got an uptake in harassment complaints against members of our Asian communities, you know, due to COVID, which obviously is a problem. Also, when, you know, the city started opening up again, we got more public accommodations, discrimination complaints with, you know, different stores or restaurants and things like that. So if that answers your question.
One of the things that I just want to call out in terms of types of complaints and trends that I know you and I, and also Susan and I, we all have talked a lot about is voucher holders being discriminated against. And it's, you know, we do see it. I think Susan referred to it earlier by saying it's often subtle. So we don't often get someone calling saying they just said they won't take a voucher. It's more that we see people kind of ghosting people, you know, so someone might inquire or respond to an ad that they see on Zillow and they show up, or they indicate in some way that they have a voucher. And there's the realtor, in most cases that I've experienced, you know, kind of comes up with another reason. So, you know, it's something we're definitely keeping our eye on. I do want to just mention one thing that some people get confused about is in a lot of the buildings that have pretty high rents and have inclusionary housing in them, and the managers are trained by the inclusionary staff, by community development, and the difference between inclusionary and market rate rent. But some folks are new, and so we're always looking to educate property managers. So someone might go to one of these buildings and, you know, say, hey, I have Section 8, can I rent? And they say, oh, you have to go through community development. And then the person might feel discriminated against because they're being told they can't rent there. It's because the manager knows that the rent is too high for the voucher. And the only way to really access those units is if they also are in the community development program. It gets a little complicated. It's just something I wanted to point out, that sometimes there's a nuance where it can be misunderstood or misguided information. So we do keep our eyes on that. There is a person on the phone with your hand up, so we will, if you want to ask your question, please do.
Yes, I have several, but one is, could you say the phone, especially Carolina's phone number out loud and not just have people looking at it since I can't see anything?
Sure. Carolina.
And what?
I was just, so Carolina's phone number is 617-349.
What was that, 349?
Correct. 4396.
4396. What's the middle section? Yeah, 617, then what?
349 617-349-4396 for Carolina.
Yes, the other comment is that I'm having trouble understanding Maura's. I don't know if you're on a different kind of mic or something, but you're very difficult to understand. The other two are fine.
Oh, sorry to hear that.
I don't know if it's something wrong with your mic, or you're not speaking into a mic, or something's.
I don't know. I can only hear myself, so I don't know if others.
It's an echo in the background.
Oh, sorry to hear that.
Yeah, it's very difficult to understand you.
Okay, sorry to hear that. I wish I had known. It
Yeah, I tried to get your attention earlier, but you didn't call on.
Got it, got it. Well, we'll try to fix that in the future. Did you have another question?
Who do you come to if when the managers of some of these buildings that have the 20%, what do you call it?
Inclusionary.
Apartments that have to be low income? When you're having
Inclusion-
trouble with the managers of those places who don't seem to know what's the difference between the two kind of tenants,
Mhm.
and often discriminate against the with unreasonable demands, and like saying that don't really apply to the low-income tenants, but they're putting them on the low-income tenants. Who do they come to address these issues?
You can contact me, 617-349-6337.
6 what?
617
617. There's one there missing. 617-349-617.
3667.
3667.
Yep. Okay, we're
Okay,
just gonna,
thank you.
you're welcome.
So that's
Another,
Maura.
correct. Another question that we have is how long between filing complaints and conciliation?
That's a great question. Conciliation can happen at any time. So sometimes after filing a complainant makes it clear that that's what they're looking for. So as soon as I have the contact information of the landlord who's often represented, I could broach that almost immediately. The other thing I'll just add in terms of how long our investigations take, we aim for under 100 days. So that number is just kind of a ballpark of like to get to the determination stage, that's how long. But sometimes, I could work with both parties to get a really speedy outcome in, 3 weeks after the complaint is filed. It all depends on kind of what the complainant's looking for. But conciliation can happen at any point up until actually even after determination. So if I find probable cause that discrimination occurred for housing complaints, either party can elect to actually send their case to the AG's office for filing, and they do their own separate action over there. Or it could stay with the commission. We attempt conciliation again. If it fails again, then it would go to a hearing before the commission. So those are kind of the different outcomes if there's a probable cause finding. If it's a lack of probable cause finding, we do not have an appeals procedure here, unlike the MCAD, the Mass Commission Against Discrimination, but you do retain your right to file your own private action in Superior Court if you wish to do that.
Great. And there's one other question that I think is a really good one. So any advice, and this is, I think, primarily for Susan, but I think Carolina, if you want to answer also, any advice on how to approach your landlord to ask to switch from month to month or a tenant at will to a yearly lease? And are there any trade-offs between the two types of leases tenants should be aware of?
I can try to answer that. So there are trade-offs. So if something is month to month, you can usually, you can leave on 30 days notice. So if, you're applying for a Section 8 or other housing, or you're planning to move across the country or whatever, you may want the flexibility and just have a month to month. If you're in an apartment and you really like it and you want to stay, then you could negotiate for a lease. Typically they're 1 year. There is the Rental Housing Association, or Greater Boston Real Estate Board, that puts out model leases that most landlords use, and they have a lot of really onerous terms. So that's the other sort of drawback of a lease. It does lock you in for a year. So if you want the flexibility of moving, you don't have it. And there's often these onerous terms, but there are other form leases that are much more simple. So there are pros and cons, but if you like your landlord and you want to fix, not have a lot of rent increases, then a lease would be the way to go, but try to negotiate something simple.
Well, this is kind of good timing. It's just about 8:30. I don't see any more questions. I will turn it back over to Chris to close it out.
Yeah, thank you everybody for joining us. Thank you very much to all three of you for sharing all that information. Just for everyone who is on the call, on the phone, etc., I will be sending out tomorrow a link to the video, the slides, as well as the contact information that's in here. So you all have that in the email that you registered for the Zoom event in. So thank you very much for the questions, we'll try and get those back. I will also just point out the Office of Maura's office has a webpage on the Cambridge website, which housing liaison is the word I was looking for. Sorry, I was confused with Somerville briefly. You can get information there and reach out to her. I am sure she loves that I just tell you that you should just go to her first for everything, but that's so really appreciate it. Thank you to all for presenting. For those of you looking to be more involved, ABC has 2 upcoming events that I wanted to pitch just so folks know. We've got our monthly ABC social on July 7th at 7 p.m. at Phoenix Landing. That's just a social hour, as well as our ABC book club on Fixer Upper coming up on July 11th at 7 p.m. at Phoenix Landing. You can find more about the upcoming events we have on our website on the events page. Go ahead, Susan.
I just wanted to add that people may know Matt Desmond had done a study and wrote a book called Evicted. And there was then a museum display in Washington, D.C. based on his book. And it is coming to Somerville. A shortened version is coming to Somerville in September, October, November. So I would urge, everybody, it's going to be at the Armory, and it's going to have a lot about eviction data and affordable housing and about tenants' rights. So I would just urge people to go to that. And also, when you send out the slide and the recording, just put, I know you in the chat, you put in the YouTube for John Oliver, but maybe I really would urge everyone. It's 20 minutes long and it's very, very informative and funny, but informative.
Well, thank you all so much. Oh, go ahead, Gomar. Sorry.
So sorry, one question came in right under the wire. I just wondered if we could take 2 seconds to answer it. What is the particular specific differences between a tenancy lease and an occupancy agreement?
There's no difference.
Great. Well, thank you very much for answering those questions. For everyone who made it out, really appreciate it. And again, you will have links in your email tomorrow morning. And thank you for joining us. And that's it for tonight.
Thank you.
Take care.
Thank you. Bye.
Bye.
Bye.